of the most common questions that's asked to a mediator in the mediation process from couples is who is allowed, which third parties are allowed, and in which situations can third parties care for the children when the parents are not. This becomes an important topic, especially when there is discussions about daycare, when there are discussions about certain family members and relatives participating in caring for the children. This question comes up. So let's begin first and just briefly discuss daycare. In a good mediated agreement, a couple is going to discuss and try to reach an agreement on who the daycare provider is going to be. Obviously, defining when that daycare is going to be, and when I say daycare, it could be preschool, it can be any work-related periods of time that third parties are looking after the children, and we will talk a little bit about non-work-related time in a minute. But this is for just during work. Who's going to take care of the kids when the parents are working? A daycare provider, if they're licensed and the parties both agree, can be an obvious option. If one of the parties has a family member that is able to take care of the child instead of a third-party daycare facility, most of the time, the courts and the trend of the courts is to gravitate to a situation where a family member that can provide that care is allowed to do that if there was ever some kind of a conflict over that. Some of the concerns that couples bring to mediation when considering who the daycare provider is going to be is obviously the cost. And that's one of the reasons that the courts will oftentimes gravitate to allowing a family member, is because it's going to save perhaps a lot of money versus going to a regular commercial daycare provider. It's not uncommon, however, though, that when a couple goes through a divorce, that the family members that each of the couples have become polarized as well. And now we have a situation where one of the parents may not feel that they are being openly accepted and welcomed, and that their children are going to be adversely affected by being cared for by that family member. So I like to use examples. If mom wants to put the child into a daycare while she's working, and dad has a sister that has offered to watch the child instead of daycare, and mom feels that that is not something that she can do because her and dad's sister have had a lot of very bad arguments and there's been some bad blood between them, and she's not going to have her child exposed to that. As a general rule of thumb, we try to encourage couples to be mindful that time is going to heal a lot, and that ultimately a good parenting plan is going to include the encouragement of allowing the children to have relationships with extended family members, grandmas, grandpas, aunts, uncles, and cousins, and things like that. Now, obviously, if there's a situation where the child has been abused or neglected by any of those family members, by the definition of the court standard of abused and neglected, then of course there's considerations to be made there. When a couple is putting together a plan and they're trying to decide who can care for the kids, another big problem that can often come up is when one of the parties become involved romantically with another person. They have a new significant other in their life. If that happens to have happened while the couple was still married, that individual many times is on the ban list. So using the previous example, let's say that dad has had an extramarital affair with a woman, and now they're getting, dad and mom are getting a divorce. It's not uncommon for mom to have some adverse feelings about that woman and her to come into the mediation and absolutely mandate that under no circumstances can their children be with this woman for any reason. That is an extreme example, but a very, very common one. And the couples come in and expect the mediator to help them through that. It's a difficult situation. There's a lot of emotion, and the mother is obviously, in that example, very hurt for a lot of reasons. Most of the time, it has little to do with the concern of the safety of the child, and there's still a lot of drama that's attached to that. As a rule of thumb, a judge will allow either party, when they have the children with them, to be around and cared for by any other third party that they choose. Now, in a mediation agreement, you can get as creative as you want, as long as you're not violating any constitutional rights. And it's very common in a mediation agreement that we put clauses in that say that for a period of time, there's going to be a cooling off before the children are allowed to be with that third party, in this case, the girlfriend. As you go through the divorce experience and you're trying to come up with a plan as to who can watch the children, be mindful that if you're lucky enough to have family members watch your children and care for them, that it will save you a considerable amount of money, and that it may be also in the best interest of your child. That should be the first filter that is always considered. In later videos, we will talk about new significant others. We'll talk about their role and how to avoid problems there. The purpose of this video segment is just to educate you about being open to the possibility that there are going to be third parties involved, and when it comes to watching your children, that you will need to, generally speaking, be more flexible and more understanding, and consider that is going to be a reality and something that needs to be accepted sooner than later.